All right, good afternoon and welcome to an oral argument session of the 5th District Court of Appeal. My name is Rand Wallace. I'll be presiding today. Joining me on the panel are Judge Eric Eisnagel from Seminole County and our newest judge, Judge Carrie Ann Wozniak from Orange County. I believe it's Orange County. And we have one case on the docket this afternoon at 3 o'clock. It is William Wilson Jr. individually and as personal representative of the estate of Muriel B. Wilson et al. And versus Clarence H. Houston Jr. et al. And Mr. Gowdy, I'm going to assume that you want 5 minutes of rebuttal unless you tell me differently. And I would just ask that everyone, if you have any noise making devices in your office, that you put them on silent so it doesn't interrupt the lawyers in their presentations. I'm sure we won't have any problem. And Mr. Gowdy, you may proceed.
Thank you, Your Honor. You're correct. 5 minutes for rebuttal. I'm here on behalf of the Wilson Trust and the other appellants. May it please the court. We have 4 issues in this appeal. The 4th and final issue I don't plan to discuss today. It is a standalone issue with respect to the set-off from a settling defendant. And if the court has questions, of course, I'll answer it. But that issue needs to be addressed however the court decides the first 3 issues, which are interrelated. And the first 3 issues all concern the validity of the 2010 deed and the trial judge's finding that deed was invalid. And we do need to win on each of those issues to get a reversal on that finding. I'm going to take the 3 issues slightly out of order and start with the undue influence, which is the second issue. But of course, if the panel has questions on a particular issue, please point me there. For the undue influence, the trial judge applied a presumption called the Carpenter Presumption. And like any presumption in the law, it allows a party to establish a fact without proving the actual fact. Here, it allows a party to to establish undue influence without having to prove undue influence. And the way that works is there's 2 prongs. One is a confidential relationship, and the other is active procurement. The party challenging the deed bears the burden of proof on both prongs. And we can state that there is no way between July 20 or 23rd, 2010 and July 30th, 2010, that the Wilson Trust developed a confidential relationship with the grantor, Mr. Boyette Sr. And if the court doesn't agree,
is it your argument that simply the short, relatively speaking, short amount of time as a matter of law means that there cannot be a confidential relationship?
No, I wouldn't go that far. I would say, though, there's no evidence here that a confidential relationship was developed during those 7 days. All the evidence, and it's undisputed, and it's even argued in the answer brief, is that before July 20th, 2010, the Wilsons had nothing to do with Mr. Boyette Sr.'s life. It was the son who controlled the financial affairs,
Who flew him to Florida?
The Wilsons paid for his ticket. He voluntarily came to Florida. Nobody went.
Sure.
I'm sorry.
Right. Nobody, I get it. But he calls and they say, sure, come on, we'll buy your ticket for you.
Correct.
He flies on their dime to Florida, and he doesn't rent a car when he gets there. He's picked up, correct?
Correct. That's not a confidential relationship.
And then, well, not yet, maybe. And then he lives with them, right? And I mean, it seems like perhaps I think the argument is, look, when you're living with somebody, you're reliant on them, and that might form a confidential relationship.
I don't think that's sufficient, that you live with someone for 1 week and you pick them up at the airport. There's otherwise short-term visits at with family members who are not immediate family members all of a sudden now we have a confidential relationship.
But it just wasn't a short-term. I mean, it wasn't a short-term visit, right? I mean, he essentially took off. I mean, the record, the testimony was he what was the word they used? He got very angry. I can't remember what the word they used to describe what happened, and it was more of fleeing the home to Florida, right? It wasn't just a friendly, I'm going to go visit family kind of thing.
Well, that's correct. And that maybe ties into the second part of our argument on the.
But doesn't that sort of contribute or have some relevance to whether there was a confidential relationship and how much reliance there was and things of that nature?
I would say that plays more into the reasonable explanation than a confidential relationship. The fact that you get berserk and go to somebody's house, even if they pay for the ticket and pick you up at the airport, that doesn't establish a confidential relationship. That's being friendly to someone, Your Honor. And if we're going to stretch I know confidential relationships have been very broad in the law, but there's not a single case in Florida jurisprudence that's near these facts where a 1 week stay and picking up an uncle at the airport now establishes a confidential relationship. As far as the
how soon after he arrived in Florida did he go meet with the attorney that knew the Wilsons?
How long was that your question?
How soon after he arrived in Florida did he go meet with the attorney?
1 week. 1 week. It was July 30th is the date on the deed, and he arrived July 23rd.
Okay, and there was evidence that the attorney had already been brought up to speed as far as what was going on with the ward. Is that correct? Before, obviously, they went to meet the attorney.
Yes, and that goes to the active procurement prong, which we've conceded on. That doesn't establish a confidential relationship between the Wilson Trust and Mr. Boyette Sr.
What about any communications that took place specific with regard to the business that was then discussed with the attorney before they went and met with the attorney?
You mean as far as between the Wilsons and the attorney, what communications there were?
Yes.
I'm not clear what is in the record on that, Your Honor. I would say though, we've conceded that the Wilsons helped to facilitate getting the attorney. I'm sure there were communications of some sort back and forth in that regard. I don't think that establishes a confidential relationship. I think and maybe if I can turn to it, because we brought up the berserk was the word used, that he went berserk. And the other part of the way this presumption works, it's very easy for it to vanish. And it vanishes if you can show a reasonable explanation for the transaction. And
Counsel, how do you square that argument, the argument you're making right now, with our decision in Hack versus Jones and with the revised versions of Florida Statute 733.107 and 90.303?
I'm going to have to look at the statutes, Your Honor. I don't know if those were raised. You said 90.303, and what was the other one? I'm sorry.
733.107. 733.107 is burden of proof in contest presumption of undue influence.
Yeah, I don't. I'm sorry, go ahead, Your Honor.
And of course, 90.303 is presumption affecting the burden of producing evidence.
Right. I don't think these statutes were raised in the answer brief. If they are, I apologize. I missed them. I'll look at those two statutes when I sit down, and I'll try to give you an answer on rebuttal. As far as
how about just Hack versus Jones? I mean, Hack versus Jones discusses both of those statutes and seems to conflict with the legal argument you're making.
No, I don't. I can address and would like to address Hack. It does not conflict. In Hack, Your Honor, what the court held is that the Florida cases uniformly hold the presumption vanishes once the proponent of the instrument provides a reasonable explanation. And what happened there was that there was a directed verdict entered at the conclusion of the presumption being shown. And what the court said was, no, you need to send this back for a jury trial. Of course, here we have a bench trial, but same concept, on the reasonable explanation. And that's exactly the relief that we're asking for here, that the trial judge should have been required, and we rely on the Jordan case for this. He needed to make a finding in the judgment on the reasonable explanation. He just ignored it. There was nothing stated at all. Therefore, and he cites the presumption without delving into this very reasonable explanation, which is that the Mr. Boyette Sr. was very angry at his son surprising him and petitioning for a guardianship. And that lines up, I would add, with the Rami case from the 3rd District from 1997, RAIMI, where there the sorry, let me get the right there. The decedent disinherited her stepdaughter because she was angry when the stepdaughter refused to return a gift. And that was found to be a reasonable explanation for the disinheritance. And therefore, even though the nephew there had a confidential relationship with the decedent and took her to the attorney to draft the will, the court found that that reasonable explanation rebutted the presumption and made it vanish, and that what the nephew had done was facilitated the decedent's decision to change her will. Here we have a reasonable explanation that Mr. Boyette Sr. was mad at his son and made a decision to not let his son get the property. So if once the presumption's rebutted under the Hack case, Your Honor, it should have gone, the judge should have had to then make the ultimate finding on undue influence, which is very difficult. And I'll read, I think the 1st District says it nicely. It has to be over persuasion, duress, force, coercion, artful or fraudulent contrivances to such a destruction of free agency and willpower. So I think I have about 3.5 minutes left. I would like to take any questions on issues that concern the court, but if there's not more on this, I do want to move on to the other two.
Mr. Gowdy, this may go into your other 2 issues. I'm not sure, but presumption aside and burden of proof aside, why could the trial court not have relied on the Texas court's findings of incapacity, if that's what your argument is?
Well, there's 2 reasons for that. The first one is, and the defense, I think, the plaintiff concedes this, no in-run jurisdiction. What they come back and say is, oh, well, you could rely on the Texas guardianship's determination about Mr. Boyette Sr.'s mental status. The flaw with that argument is it misconceives the fundamental difference between what any guardianship court does, whether it's in Texas or Florida, and what had to be done here, which was here we had to look back and determine whether or not Mr. Boyette Sr., I want to get the exact words, but under this court's Gracie case, understood so was he so affected by his mental disability so as to render him incapable of comprehending the nature and effect of the transaction. It's backward looking. In a guardianship court, we're forward looking. We're examining the mental and physical condition of the ward and taking measures to protect the ward. And the Texas court in KLM, Texas Supreme Court, made that very, very clear, Your Honor, and there's no rebuttal to that in the brief. And that is that the guardianship court is determining the incapacitated person's status at that time, and its only effect is on transactions anytime thereafter. It doesn't look back. It says there is no legal authority in Texas for the proposition that a guardianship determination has retroactive effect. And the
The
second piece,
guardianship proceedings were ongoing when the deed was executed, correct? And the
No.
Wilson defendants knew about the guardianship proceedings?
well, it had been initiated, but that doesn't mean that a guardianship had been established. And the expert doc, I see I have a minute of time, Dr. Rochelle, he was very clear in his testimony that he was only determining the capacity, the mental status of Mr. Boyette at the time of the examination, and he wasn't trying to retroactively look back. And we cite a series of Florida cases, and I won't go through them all, I don't have time, but make it very clear that it's the moment in time. And I would just make an analogy to what I do in post-conviction work. You can't come in after the fact and say, well, my client has a mental illness, he must have been incompetent at the time of trial. You look at the time of trial, why we want to keep convictions, they're sacred. Same thing with legal instruments. I see I'm into my rebuttal time, so I'll reserve unless the court has more questions.
Okay, Mr. Korn.
Thank you, Your Honor. May it please the court, I'm Michael Korn of Korn and Ziemer in Jacksonville, and along with the Woolsey Morecambe firm, we represent the appellee. First, I do want to thank the court for its courtesy as well as Mr. Gowdy's courtesy in moving the oral argument to today, and I appreciate that personally. Mr. Gowdy correctly says that of the three matters that he's raised on a substantive level, he's got to win on all three. He can't win on all three. In fact, I don't think he wins on any of them. Any of the three matters, if the court finds are sufficient, as the trial court did, will require affirmance of the court's order. Let me first, if I might, address some of the points that Mr. Gowdy was making in response to Judge Wozniak's questions. You know, it's intriguing when you look at the testimony of Dr. Rochelle, which is correct. He was the only person who actually, with a medical degree, testified in this case. He gave a report in Texas back in the 2011 period, the 2010-2011 period of time, and he also was deposed for this particular litigation in St. Johns County. Mr. Gowdy somehow wants to create this like bubble of time that only at the moment that he gives the opinion can it be relevant. But what's important when you look at Dr. Rochelle's report, he specifically mentions the fact that Mr. Boyette Sr. had reported that he was having various memory problems, concentration problems for at least 6 months. He had been having anxiety for at least a year. And not only that, but of course, Dr. Rochelle finds that Mr. Boyette Sr. was suffering from paranoid ideations and a variety of things that compromised his mental state. So the idea that somehow there's some difference between looking back and looking forwards, of course, the medical expert has to be presented with evidence and testimony that established what this gentleman was going through when he presented. He was not, it wasn't just beginning of dementia. Dr. Rochelle opined that he had probably been at least 2 or 3 years into that path. The record also shows that he was under medication for dementia. And we have to go back then also.
Counsel, the testimony, wasn't there testimony that he would have good days and bad days, and some days he was lucid and other days he wasn't? Doesn't that sort of lend some strength to opposing counsel's argument?
Perhaps the only thing that could lead strength, Your Honor, it was the honest testimony of Boyette Jr., which said good days and bad days. But what we have here is a sad and unfortunate continuum of decline. And that was established not just by...
In theory, if on the day he executed the deed, he was perfectly lucid that day, then, you know, why should the deed be invalidated? I mean, should it be?
Well, it should, because there is competent substantial evidence in the record, which this trial judge weighed over a 4-day trial and determined that this was not an interval of lucidity. That was the same finding, by the way, Your Honor, that the Texas court had made in the February 2011 order, that it was not.
Minus the Texas court's findings. Let's assume for a moment that we conclude that those cannot be relied on. what other evidence is there to establish that on the day of execution?
Well, you can't rely on the lawyer because, and of course, Your Honor, I have to point out, Mr. Gowdy was referring to, I think in response to a question from the panel about when Boyette Sr. met with the lawyer. He actually met with two lawyers. He met with a lawyer before he met with Attorney Hamilton, who was the lawyer who drew this deed in question. A day or so before that occurred, on the 27th of July 2010, he met with Attorney Sanders. Sanders was the one who knew that a guardianship was in place in Texas, or had been sought in Texas. It wasn't in place yet. It had only been filed a week earlier. He arranged for a revocation of the power of attorney, and he arranged for a new entire will to be created, now leaving everything to Boyette Sr.'s sister, Muriel Wilson. So there were two incidents where lawyers were procured by the Wilsons in order to obtain property belonging to Boyette Sr. I just want to make sure that the court recall that it wasn't just the lawyer who dealt with the deed, two separate attorneys, Sanders with the power of attorney, and the new will, which basically makes Muriel the personal representative and the full beneficiary, and upon her death, it goes to the Shriners. And then the second attorney, Hamilton, who admitted, Judge Eisnagel, that he met with Boyette Sr. for maybe 5 minutes. He didn't make any evaluation of his capacity or credibility, other than to assume that he wanted to do this because he was there. He showed up at his office. Well, he showed up at his office because he was carried there by Wilson Jr. and by Muriel.
I guess what I'm trying to find out is what, other than the Texas court's findings, what other competent substantial evidence is there in our record as to the ward's capacity on the day that he signed the deed? Well,
we can't put ourselves in the minds of Wilson Jr. or Muriel. Muriel sadly has passed away. But we do have testimony that the trial court was correct in relying upon from Boyette Sr.'s daughter, Gay, who talked about her father's unfortunate decline, that he wasn't getting better, that he had gotten worse. He used to get lost.
None of that, I mean, in fairness, right? None of that was directed toward the day that the deed was signed, right?
Well, yeah, this presents kind of an interesting situation where you may have two separate concepts of incapacity and undue influence, but here there is something of a merger of them, and one either enhances or degrades the other. What the appellants want to try to have this court not consider is this man at the time was 90 years old. And yeah, he went berserk. He went berserk because he thought that he was being involuntarily committed. Not that that anything else was happening. They also forget and don't point out the fact that the whole reason this started was he was living in an assisted living facility in suburban Dallas. The management of the facility came to Boyette Jr. and said, look, your dad is exhibiting inappropriate behavior to some of our female residents. You got to do something about this. And that was what triggered the event that he filed on July 20. He served on July 21. And on July 23, he's on an airplane to Florida. Now, to your specific question, we can, short of Wilson Jr. saying he was fine and fit as a fiddle, we can't go to anybody else and have necessarily rebuttal testimony.
Right. So that's what I was getting at, counsel. So do you need the presumption, or let's say if the presumption's out of reach for you here, can you still make a capacity argument based on evidence in the record, or do you need evidence on the day that the deed is signed?
I don't believe so, and I think we can make it either way. And because we have not only the issue of this gentleman's diminished capacity, we also have the dependency issue. When he comes to Florida, he's picked up by Wilson Jr. He drives from the Jacksonville airport to Lodi, an hour plus drive.
But that sounds like you're back on the presumption of undue influence, though.
Well, but Your Honor, I do think that there is some level of overlap between the two because one affects the other here. But when he arrives at the home of the Wilsons, he is now totally and completely dependent upon them. And so is that undue influence, or is that basically an incapacity argument? He was incapable of caring for himself. He had no cash, according to what Wilson Jr. testified.
I don't, the fact that he doesn't have any cash, I'm not sure that legally has anything to do with his capacity, counsel.
Your Honor, I understand what you're saying.
Counsel, it might have something to do with a confidential relationship and reliance and all that stuff, right? But I'm not sure that I'm failed to see how that has anything to do with actual capacity.
Well, the only thing let me put it this way. This gentleman was not in good straits by anybody's testimony. Even the Wilsons acknowledged that he was mad as a hornet. And I think that the trial court could have appropriately said that the man wasn't thinking clearly, because he is now going to give a valuable piece of waterfront property and all of his other assets to family that he had no real use for, and frankly, a family that had no use for him.
Counsel, he had every right to do that, assuming he had
capacity.
Right.
And in this instance, Your Honor, we respectfully submit that the trial court, who appropriately considered all of the testimony, including the testimony of Boyette Jr., his daughter Gay, the testimony of Dr. Rochelle, which kind of established the path, unfortunately, that Boyette Sr. was on at the time, and more importantly, can reject as fanciful or just incredible some of the testimony of Wilson Jr., that this man was fit as a fiddle. He was a remarkable specimen. What the appellants want this court to do is basically reweigh the testimony that the trial judge heard during this rather lengthy bench trial.
Well, that's counsel, I'm not sure that's right. On the issue of legal capacity, which is a separate issue from the presumption, but on the issue of capacity, I think what they're arguing is, look, you may have had evidence of incapacity months before the deed was signed. You may have evidence of incapacity months after the deed is signed. But what they're saying is there's no evidence of incapacity on the day the deed was signed. I think that's their argument, or one of their arguments anyway. What do you say to that?
I would just suggest that the evidence that they're relying on could reasonably have been rejected by the trial court when he weighed the testimony primarily of Wilson Jr., who was the one who was actively procuring these actions on behalf of, in the name of, his mother Muriel. So the court could have, I think, reasonably rejected any contention by the Wilson defendants that there was capacity at the time he signs this deed, where he's never seen it before. He didn't talk to Hamilton. Only the Wilsons talked to Hamilton. He shows up and he meets the lawyer for less than 5 minutes, and then it's signed. In fact, when Hamilton was asked during examination at this trial about the Texas guardianship status, unlike Sanders, who knew all about it and was actively working to override or do an end around on it, Hamilton said, I didn't know about the guardianship, and had I known about the guardianship, I would have taken other action. That in and of itself, I think, is a significant piece of evidence, because as the case law says, and it's often in the undue influence situation, but again, there is some level of overlap. It's highly unlikely that parties are going to take action that is in front of a lawyer that's going to trigger some kind of a problem that would deal with the enforceability of these obligations going down the road. So for those reasons, Your Honor, I do believe that there is evidence from which the trial court could have appropriately found incapacity on the day that the deed, the July 2010 deed, was signed. The issue about Carpenter, of course, what's interesting is that the trial court should have made a finding about this reasonable explanation. There was no reference in their motion for rehearing to any lack of findings under Matthew. That shouldn't have been deemed as a preserved argument. And we believe, and it was, I think, shown in our brief, that each of the elements of Carpenter were met, and that we met our burden of establishing that the presumption should apply. And the appellants did not meet their then shifted burden of showing that this reasonable explanation existed. Some of the questions from the panel have already touched on some of those key facts. within less than a week, people who absolutely hated this man, called him a piece of garbage. Muriel, who said that her dying wish was that Boyette Sr. should not be allowed to attend her funeral. We're supposed to believe that without any influence, without any prompting, he would entirely change his estate plan, revoke a power of attorney, and deed whatever interest he held in that property in Palm Valley to Muriel. As the court's also aware from the other issues, there's some question about what Boyette Sr.'s percentage interest in that property was. And the court will recall that there was testimony at trial from the closing attorney who was trying to close the transaction when the Wilsons were selling this property to the third party Hofstetler. And the question was, well, did he have 50%? Did he have 75%? To some extent, Your Honor, one could say that if I don't know how much of a percentage of my interest in the property is, that in and of itself is sufficient evidence to show that there is a lack of capacity. I didn't even know how much I was giving over when I signed this deed in July of 2010.
And so what about the set-off issue?
I'm sorry, Your Honor?
Yeah, what about the set-off issue?
The set-off issue is the settlement dealing with Hofstetler occurs right before the trial begins. And Attorney Griggs, who represented the defendants at trial, just specifically said, Your Honor, I want to preserve the issue of set-off. And the trial counsel for the estate said, we don't have any problem with that, but right now we're getting ready to start this trial. You know, we can deal with that at some point down the road. And what's intriguing is, although that was stated all off record, it's in the transcript, the Wilson defendants never actually filed a formal motion for set-off. We acknowledged in our brief that if a set-off was appropriately sought, then they can do it by an appropriate motion. But they can't fault the trial court for not making a determination on set-off when no evidence was presented before it and no motion was actually formally before the court.
Does set-off have to be raised as an affirmative defense in this situation?
It's Your Honor, it would normally be an affirmative defense. Of course, in this instance, the event that would lead to the purported set-off, which was the settlement between the third-party purchaser and the estate, only occurs on the eve of trial. So to the extent that there should have been an amendment to the pleadings on the eve of trial, I'll refer to the record as obviously the pleadings weren't amended to establish the set-off by the defense.
Was there ever an attempt to amend the pleadings?
Not as to this issue, not as to the set-off issue.
Right.
So it's a separate issue. It's not substantive, but the trial court certainly can't be faulted for it. And even when you look at the testimony on day one of the trial, Griggs simply says, "I'm doing this to preserve our right to seek a set-off." Okay, well then seek a set-off properly. File your papers, and we can make a determination. There's nothing in this record that tells us anything about what any set-off might be and whether it's appropriate or not. And that was what the estate's attorneys correctly acknowledged at the time, and what we said in our papers before this court.
The appellant's attorney did raise the set-off issue in the written closing arguments and in the motion for rehearing, correct? There just wasn't a motion to amend the pleading.
That's correct, Judge. In fact, that was the primary focus of the motion for rehearing was the argument about the set-off. But there's still nothing in there that would give the trial court any idea how much set-off was even on the table, much less how much of it should be appropriately applied. And of course, there was no actual operative motion that the estate could make an appropriate response to. So
what should the motion have said in your ideal world? It should have laid out, maybe they didn't know how much the settlement was. What should it have had in it?
Well, they would have said that on the eve of trial, I don't know if it was the eve, but very shortly before trial, a settlement occurred between Hofstetler and the estate. We, the defendants, believe that we're entitled to some offset, and the court should make a determination as to whether we're entitled to an offset, and if so, how much. And then there would be either production of documents, normal discovery, like as you have in any litigation, but none of that is here. And the trial court, neither the trial court nor the estate can be faulted for that.
At any point, did they attempt to conduct any discovery, take a deposition so that they could determine the facts surrounding the settlement?
There's nothing in this record that reflects any of that activity whatsoever. No. The motion for rehearing just simply said court should have considered the offset, but all that the trial counsel asked for is I want to put a placeholder and reserve my ability to seek the offset. That's the sum and substance of what occurred post trial with respect
What if
to
they had proven up? What if they had proven up the set off at trial, and then asked for it in closing argument, but just failed to file a formal motion, to add an affirmative defense?
Well, in those, there could always be the application of the doctrine that the issue was tried upon consent, for instance. But here, the issue was not tried, much less by consent or otherwise. It was an issue without facts, and so therefore nobody could have made a proper determination about it. I see that my time's expired. I do want to rely upon my brief for all the other points that we raised. Again, any of the three bases for finding this case was appropriately decided, whether it's full faith and credit, independent incapacity, or the Carpenter Presumption on undue influence leads to affirmance, and I thank the court.
Gowdy.
Thank you, Your Honor. I want to start with the set off, page 46 of our initial brief. Mr. Korn's mistaken about the record. At page 4224, we did file a motion for leave to amend. I've reviewed it. We did not, I admit we did not attach an answer, but if you look what's stated there, it's almost exactly what Mr. Korn just told you a moment ago, should have been put in the motion. And anyway, that was done 3 weeks before trial, Your Honors. There wasn't time to have discovery at that point. We needed to get that motion granted. It was brought up again the first day of trial. It was then brought up in the written closing argument.
There wasn't time. There wasn't time for a deposition in 3 weeks.
Well, not if we didn't have leave to amend. We asked for leave to amend 3 weeks before trial. We weren't granted it. We're not allowed to go forward on things that we don't have permission to do. But as far as preservation, I'm not sure what more could have been done, Your Honor. This happened just on the eve of trial. And of course, there's lots of other things going on and getting ready for trial, but we 4 separate times brought it to the attention of the trial judge. And to say there wasn't a motion, there was. It was page 4224 of the record. Did
you move forward with asking for a deposition? Did you try and notice a deposition? Obviously, they would have filed probably a motion in limine or something to block the deposition. But did you go forward with that attempt?
No, and Your Honor, I think this is really very simple. They're just going to tell us the amount of the settlement. I don't even know why we need to have
counsel. That's why 3 weeks is plenty of time for a deposition. This doesn't sound like it's a really complicated issue to figure out. It seems like an hour-long deposition anytime in that 3 weeks, or even during trial in the evening or something, would have sufficed, right?
Your Honor, I guess if a trial lawyer tries to notice a deposition that's not framed by the pleadings, there will be an objection that will be sustained. You cannot just have discovery on matters outside of the pleadings. We filed a motion for leave to add this. We learned at the last minute. Had it been granted, then yes. And trying to get a hearing time in the circuit court in the 7th Judicial Circuit in less than 3 weeks is impossible, Your Honor, as a practical matter. I don't know what else this trial lawyer could have done to bring this to the attention.
Just to cement your position on this, your position is that set-off had to be raised as an affirmative defense. It had to be pled as an affirmative defense.
I'm sure if it wasn't, plaintiff's lawyer would have objected. Yes, that's the law. So we tried to get it. We couldn't get it. The fact, if we had gone forward with the deposition, we would have probably been sanctioned, I think. I just don't understand how that could have done it. It was outside of the pleadings at that point. I do want to move on to the more important issues. As far as the capacity, you brought up the good day, bad day, and we heard the same argument again. Well, the judge didn't believe the Wilsons that it was a good day. We didn't have to prove anything. The presumption under the law is that every instrument is valid and that the grantor had capacity.
But if the presumption of undue influence triggered, then is it your position that I think that opposing counsel's position is, look, that once that presumption triggered, the burden shifted permanently. Is that do you agree with that or disagree?
So I disagree, and I did get to look at the two statutes that you mentioned, Judge, and they weren't mentioned in the briefs. But once I think all those statutes change, Your Honor, it looks like it was a 2014 amendment you're referring to. It would have changed us from a burden of production to a burden of persuasion. But I don't think that wipes away the reasonable explanation. So first, they have to prove a confidential relationship. They didn't do that. I won't go over that again. If they did prove a confidential relationship, then it would shift to us to prove the reasonable explanation. The judge didn't evaluate it. We argued it in closing. He said nothing about it. The Jordan case says the judge needs to make finding. I see I'm out of time, but I'd be happy to ask more questions if Your Honors has one.
Thank you very much. And we're in recess.